He walked into court claiming he wasn't driving, wasn't subject to the law, and was untouchable. Judge Simpson watched the evidence stack up, blood, body cam, fake diplomat plates, and shut it down fast. End result? Bond continued. Charges upgraded, and reality won again.
Thank you. Mr. Magoo, can you stay?
Daniel Magoo.
Thank you.
Your Honor, the defense is ready to proceed to examination in each matter. I'd ask for a sequestration order.
I anticipate one witness in each case.
All right.
So it should be over.
All right. Witnesses are ordered sequestered for what that matter.
Actually, Your Honor, I have
you may have, yes.
I have an issue. I have been requesting the last time I was here, requested that the prosecution provide explanation for the undue delay.
Your Honor, my advice to Mr. Magoo was that I'd be handling the examination today. So just for purposes of the record, I'm advising you not to make any statements on the record of this.
Well, I do actually also want to provide notice that this case is being removed under 28 USC 1455 to the Eastern District of Michigan under case number 25-12440, and due to due process violations that I've been facing.
I don't know what you're talking about. The case has been removed.
I'm sorry. I'm providing notice of removal.
This sovereign citizen is back in court thinking today is the day he beats the system. Judge Simpson reminds him this isn't YouTube law school. This is real court with real consequences. This is his last stop before circuit court, and the evidence is already stacked. Spoiler, denial doesn't dismiss felony charges.
Under case number 25-12-12440.
Have you talked that over with your attorney?
I let him know.
Your Honor, and my advice was I'm not going to be joining in any collateral motions or actions, and that I would address the case.
Are you aware of any motion that seeks to take this case to federal court? I'm not sure how that would even happen.
Right, Your Honor. And Mr. Magoo told me that he has been seeking that action, but I informed him that I am not a member of the federal bar and that I would not be joining him in any of those actions.
Just providing notice.
Okay, I don't know what the notice does, but I'm not. If I don't have something in writing indicating some procedural aspect to it or anything along those lines, the court's not.
Can I give this to you now?
I would advise against.
I don't even know what is
Notice of removal pursuant to 28 USC 1455 criminal.
what does that statute read?
The criminal proceedings removed to federal court under federal questions involved in this case.
I'm not gonna get a bite as to what federal questions, because I don't think there are any federal questions.
Fourth Amendment violation.
Which adequately a state court could handle if that were an issue. So I don't think there's any need for the court to even deal with that. I don't know that anything's been filed with the federal court regarding that or anything else.
Filed under case number 25-12440.
Are we ready to proceed?
Defense is ready to proceed, Your Honor.
People ready to proceed?
Yes, Your Honor.
All right.
In
Which case would you?
We were talking over each other. I apologize. If it pleases the court, could we start with the OWI matter?
That being 0523.
I believe that's correct. Yes.
That's fine. Start with that one.
Thank you. A couple of housekeeping matters. The court is in receipt of the amended complaint, which is just taking it rather than the felony form. Is that correct?
I do have an amended information. I do.
Excellent. And Your Honor, I do believe defense is stipulating that the defendant has 3 prior OWI convictions.
So stipulated, Your Honor.
So there's a step to the priors.
There it is, Your Honor.
All right. Anything else?
I do think defense is going to stipulate to people's exhibits 1 through 10, which are photos, but maybe not?
Your Honor, I did have an opportunity to review those and we would so stipulate.
And then people's exhibit 11 is a laboratory report. I'm not sure if there'll be a stipulation to that as well.
We would so stipulate.
I'm sorry?
So stipulated, Your Honor.
Okay, so exhibits 1 through 11 are stipulated to,
Thank you, Your Honor.
therefore admitted.
Thank you. I do expect that the officer in charge of the other matter will probably be informed at some point if sequestration order is otherwise enacted and followed. So I will call Paul Corey to the stand.
All right.
He announces his case is removed to federal court, like he's reading a magic spell. Judge Simpson shuts it down instantly and asks the only question that matters. Where's the order? No paperwork, no authority, just confidence and confusion. Federal court doesn't work off vibes.
Take Seabright's part, and you saw swear affirm testimony about the truth,
Were you working for the Milan City Police Department on or about March the 27th, 2024?
I was,
Do you recall what shift you were working that day?
midnight shift, 6 p.m. to 6 a.m.
And were you ever at the location of Dexter Street and Arcona Road?
I was.
About what time were you at that location?
About 1:35, or when I was dispatched there.
Why were you dispatched there?
The 911 caller had said that there was a single car crash into a gas station in that area.
Did the 911 caller, did you have any other information in your dispatch when you were headed that way?
Objection, Your Honor, calls for hearsay.
Your Honor, it's not being offered to prove the truth of the matter asserted. It's being offered to prove why he was headed to that location and other additional information that may have hastened his speed going that way.
All right. I will overrule the objection regarding hearsay. I'll accept it for what it's offered for, other than the truth of the matter.
Thank you. Did you have any other information from the dispatch?
I believe that the caller said that there was a single subject walking around outside of the car and possibly injured.
When you arrived, what did you observe?
A car that was, I saw a SUV that appeared to have been crashed into a sign outside the gas station here. Dexter, and there was a single male subject standing around the passenger side of the vehicle.
What did you notice about the vehicle first?
It was definitely crashed there and not parked. There was some extensive front end damage.
Officer Corey, you took some photographs that evening.
Yes,
Did you take a photograph of the vehicle as you found it?
I did.
Actually, more than one, would that be fair to say? All right. And when you saw the vehicle, how did you determine that it had been crashed as opposed to just parked there?
Due to the amount of front end damage that it had, and it was still in contact with the signage there.
Did you make any observations about any other parts of the vehicle?
It was the windshield was smashed in a particular fashion.
And go ahead.
It appeared that it was impacted from the inside rather than the outside.
How could you tell that it was impacted from the inside rather than the outside?
It was falling outward instead of inward, and there was no gouging from the outside of the windshield.
And when you were looking at the windshield, would you describe the cracking in any particular way?
In a circular fashion. It's front of the driver's seat.
Did you look inside of the vehicle?
Yes.
Where did you observe about the inside of the vehicle?
There was quite a bit of personal property inside of the vehicle, and the passenger and all of the front and rear passenger seats, indicating that there was probably only one occupant at the time of the crash.
Did you look at the windshield?
Yes.
What did you observe about the windshield?
What stood out about the windshield was there was a clump of human hair attached to the cracks in the impact area on the inside of the windshield.
How would you characterize the color of the hair that you saw?
Light brown, maybe dark blonde.
Did you make contact with any people at that location?
Yes, there was a male subject standing near the passenger side of the vehicle when I arrived.
Do you see that person in the courtroom today? Can you tell me where that person is sitting and what they are wearing?
Seated at the defense table during the hearing notice.
Your Honor, may the record reflect that witnesses identify the defendant?
No objection, Your Honor.
Record shall so reflect.
And sir, when you made contact with the defendant, what did you talk with him about, or what did he do?
I asked him what had happened.
What did he say?
He said I wasn't here.
Car smashed into a pole. Windshield broken from the inside. Blood and hair embedded in the glass. And the defendant standing right there. This isn't theory or speculation. It's physical evidence doing the talking. Reality doesn't care what you claim happened.
What else did you notice about his appearance?
He was bleeding from a cut or some type of injury. There was a lot of blood. It was kind of hard to tell where it all was coming from. It appeared it was bleeding from the top of the head.
Did you notice anything about his clothing?
It was disheveled. There was blood on it. Front zipper was down. The zipper was down on his pants.
Did you look at the color of his hair?
Yes.
Based on your observations, did that appear consistent with the color of the hair in the glass inside the car? What happened next?
He maintained that he was not driving the vehicle. He could smell the odor of intoxicants coming from him. We called for medical assistance just based on his injuries. And so while they were on the way, asked if he would take a preliminary breath test, which he agreed to.
Without getting into the results of the preliminary breath test, did you make a determination about what had happened that evening?
It appeared on his face that he was driving the vehicle and it got into a crash. And he may have been intoxicated while he was doing it.
Did you place him under arrest for OWI?
Not at that time.
When did you place him under arrest for OWI?
After the ambulance came, it was determined he was going to go to the hospital while he was receiving medical treatment, and I read him his chemical test rights. I advised him at that point that he was under arrest.
Did he agree to take a test?
No.
What happened?
He refused to take a test. Poor judgment on my part. I did not have him restrained in the hospital bed while I left I believe that his injuries were significant enough that he was not going anywhere. I went out to my car to start preparing a search warrant for his blood, at which point a nurse came out and told me that he had fled the hospital.
Did you find him?
With some assistance from Washington County Sheriff's Office, yes, I did.
Where did you find him?
An apartment complex just south of the hospital.
Were you able to take him back to the hospital?
Yes.
And did you complete your search warrant?
Yes.
Was it executed?
I just a note for the court, Sergeant Crusadis, helped me prepare the search warrant while I was dealing with Mr. Booth's hospital. However, I did review, since I was going to bring to the warrant, I did review to make sure it was accurate based on my observations at the time of the incident.
Did he make I'm sorry, go ahead. No, I'm so sorry to interrupt you, sir. While you were waiting to do the blood draw, did he make any statements to you?
He looked at my uniform and appeared to be confused as to why he questioned me as to why Milan, the city of Milan, was doing all of this. And
what did you say to him?
Asked him where he thought he was, and I said he was insane. Thought he was insane.
Did you ask him to perform standardized field sobriety tests?
I did not.
Why not?
Mainly due to his injuries, and even though he did comply with the request for a PBT, he was generally uncooperative with most things that we were trying to get him to do, or asking questions about what had happened. So then based on the extent of his injuries, we were more concerned about getting the medical attention at that point.
In your training and experience with administering standardized field sobriety tests with people who've been in traffic crashes that have injuries, is there any guidance that you've received from NHTSA on that?
It can be, especially with what was clearly a head injury that was sustained in a vehicle crash, it could have impacted the results of the standardized field sobriety test.
Your Honor, may I approach with People's Exhibit 11, the laboratory report?
You may.
And Officer Corey, you did receive a laboratory report back in this case? And do you recall what the VAC was?
I believe it was 0.127.
Asked what happened, he responds with, "I wasn't here." Classic sovereign citizen logic. Deny reality and hope it disappears. Unfortunately for him, the poll, blood, and photos all disagree. Courtrooms run on facts, not imagination.
What did you do with the vehicle? Or what was done with the vehicle? Let me ask that. Do you know what happened with the license plate?
We confiscated the plate, as the operator at the time, who we believed to be Mr. Magoo, had several prior convictions for suspension and operating while intoxicated, requiring a plate confiscation.
Pursuant to state law, you had to take it. And I may have a moment.
I do have one question. How much time elapsed between the time you were notified that he had left the hospital and when he was located? Do you know?
I believe it was about 40 minutes, Your Honor.
40 minutes?
40, yes, Your Honor.
Okay. All right.
And Your Honor, I would pass the witness.
All right. Cross-examination.
Thank you, Your Honor. May I inquire? Afternoon, officer. My name is Alex Warren Green. I represent Mr. Magoo in this case. So you're dispatched for a single vehicle accident, right?
Correct.
And that's at a mobile gas station, and it appears there was an accident from an SUV into the sign, the mobile sign, right?
Correct.
And like you testified on direct examination, there was a 911 call placed, and that person didn't provide a name, did they?
They may have. It's something that I didn't end up following up on.
So you never talked to the caller, did you? And are you aware if anyone talked to that caller?
I am not aware that anyone did.
So as soon as you get there, Mr. Magoo is on the passenger side of the vehicle, right?
Standing outside. It's on the passenger side.
Okay. And that car was not registered to Mr. Magoo, was it?
Correct. It was not.
And like you testified on direct examination, he had a wound to his head, right?
Yes.
It's bleeding pretty bad.
Yes.
There was an injury to the front and back of his head, right?
There's photographs of an injury to the back of his head, yes.
Okay.
And the front.
And he appeared to be dazed.
Yes, it was difficult to say if he was out of it due to the head injury or his level of intoxication, maybe a bit of both.
And you didn't conduct the field sobriety test because you were concerned that the head injury you observed might impact the field sobriety test, right?
There was a possibility, yes.
So you testified on direct examination, you saw the windshield was smashed and you saw blood, right?
Correct.
There's a chunk of hair in the windshield, right?
Yes.
You take a picture of that?
Yes. Let me backtrack. Sergeant Mercedes actually took a photograph of it.
Okay. And most of the time you're talking to Mr. Magoo, he was wearing a hat. You recall that, right?
I don't recall that. He may have been.
So it's dark outside, right? And
Is that a yes? 'Cause I don't think we got.
oh,
Oh,
so,
I'm sorry, Your Honor.
It's okay.
Yes, it was dark.
Okay, go ahead.
and there's a significant amount of blood on his face and it's going into his hair, right?
Correct.
Okay. In this case, you did submit evidence to the crime lab for forensic analysis, right?
Blood test, yes, blood sample.
Right. So no hair follicles, right?
No.
And there was no attempt to obtain any forensic match between the hair or the blood that was found in the car with any hair or blood from Mr. Magoo's body, was there?
You were correct, there was not.
Okay. On direct examination, you talked about field sobriety tests. You said you're trained in the administration of field sobriety tests, right?
Yes.
And you forewent the field sobriety tests in this case, but no one asked him at all to perform those field sobriety tests, did they?
That's correct.
And after this initial interaction, when, the ambulance arrives, he goes to Trinity Ann Arbor Hospital, right?
Correct.
And did you accompany him in the ambulance or you follow behind?
All behind.
Okay. And you read him his chemical rights at the hospital while he's in the bed, correct?
Correct.
And he refused at 2:51 a.m. Is that?
Correct.
And after he refuses, you leave the room to go and work on the affidavit for the search warrant, right?
Correct.
And then Mr. Magoo vanishes.
That is also.
Okay. You didn't see him leave.
I did not.
You had no idea where he was.
Nope.
And like you said, he wasn't handcuffed or in any way restrained to that bed, was he?
He was not.
And there were no officers standing at the door or otherwise supervising that room, were there?
No.
And through your investigation, you determined he's located at an apartment complex at around 3:40 a.m. Is that right?
That's what is in the report. I think I listed a time in there. If you want me to look at, refresh my memory.
It would refresh your recollection to look at your report?
It would.
Okay.
Yes, I did. He was located about 3:40 a.m.
Okay. And he's returned to the hospital. The blood draw was completed at 4:28 a.m. And of course, there's two blood draws done. So it's 4:28 a.m. and 4:29 a.m. Does that sound right, officer?
That sounds correct.
Okay. So in an ideal OWI investigation, you want to have eyes on the subject from the time you make the scene until the needle enters the arm, right?
I do. Yes.
Okay. One of the reasons you do that is to make sure the subject doesn't consume anything that could impact the blood test, right?
That is correct.
And Mr. Magoo was unaccounted for nearly an hour in this case, right?
That's correct.
And in your search warrant affidavit, you didn't mention that, did you?
I don't believe so, no.
Thank you for answering my questions, Your Honor. I have nothing further at this time.
Blood test comes back at 0.167 BAC. That's not borderline. That's full commitment to bad decisions. The evidence keeps piling up while the excuses fall apart. Numbers don't lie, even when defendants do.
Thank you, Your Honor. Officer Corey, were you able to obtain information that the defendant had previously been pulled over by a different police agency operating this car in March of 2023? And after he was recovered and brought back to the hospital, did you have two deputies stand by with him and handcuff him to the gurney?
I handcuffed him myself, but luckily I had a couple of deputies that were free for the moment that were able to watch him while I finished up the search warrant.
Thank you. Nothing further, Your Honor.
Anything?
Your Honor, if I may, one.
May want to mute your microphone.
Your Honor, just briefly. Thank you. Officer.
Oh, and can I just ask one other question before you, and I'll let you ask your question.
Of course, Your Honor.
The PT, if there's
Alex muted.
okay, the PBT, are people going to seek admission of that if defense is challenging the results
Yes, Your Honor.
pursuant to the statute?
Correct.
And Your Honor, I understand that the people could rebut that kind of challenge. I'm not sure that we have gotten to that point yet. The case law.
Well, I just want to make sure that if there is going to be a challenge to the results, that under the statute, my understanding is, although these aren't entirely the circumstance under which it happens, but it seems to me an analysis could be made that the PBT would then become admissible. Just so that defense counsel is aware, but you may inquire.
Thank you, Your Honor. I appreciate it. Officer, before Mr. Magoo was admitted to the hospital, did you yourself search him? Search his person?
It's outside the scope of my redirect, Your Honor.
I'll allow him to ask. Go ahead.
He was wearing a jacket, right?
I believe so, yes.
Do you go through all the pockets of that jacket?
I normally would, yes. I believe I did.
Okay. Officer, when you completed the refusal to submit to chemical test form, in this case, do you recall writing the refusal time as 1:35 military time?
No, I don't recall that.
Would it refresh your recollection to look at the refusal to submit to chemical test form you completed?
I would. I think
Yes.
seems that I did. I don't recall why I would put that time there.
Well, again, officer, thank you for answering my questions. Your Honor, I have nothing further at this time.
All right. Ms. Lundy.
Officer Corey, you would agree with me that this says refusal date, but it does not say refusal time, correct? It just says military time?
Correct.
Okay, thank you. And lastly, Your Honor, in anticipation of an argument that the blood result is not accurate, I would ask a question about the PBT, but if that argument's not going to be made, then I don't need to.
Your Honor, I would object to any mention or admission of the results of a preliminary breath test in this matter. I'm not sure that I have raised an argument that regarding its accuracy or regarding a rising blood alcohol level or anything like that. I don't think I've opened the door for that.
Well, I don't think you have. I just want to make sure we're prepared for the argument. But if that argument is going to be made, then I'm going to let the people question as to that. But
Your Honor, I don't anticipate making an argument regarding a rising blood alcohol level or anything to that effect at this point.
well, but are you going to make the argument that the blood alcohol result at the time of the test, well, I'll just do it this way, is it lower or higher than the?
Your Honor, I intend to make arguments on what has already been stated on the record, and I'm not to.
What does that mean?
From the defense, I don't anticipate any further questioning regarding the blood alcohol results from either the lab or the preliminary breath test.
Okay, again, that was very cagey the way that was put, but I'll just put it this way. What I will do, Ms. Lundy, is I will not permit the questioning at this point. However, if it is raised in argument, I may entertain a motion by the people to reopen their proofs to take testimony regarding that.
Thank you, Your Honor.
Understood, Your Honor. Thank you.
I have nothing further.
All right. You may step down, sir. Thank you.
Shockingly, the defense attorney is doing real legal work. No sovereign slogans, no jurisdiction rants, just actual arguments. And even then, the facts are still crushing. You can polish it, but you can't erase it.
Anyway, court recalls the case, People versus Magoo.
As spells to people.
Alex Warren Green on behalf of Mr. Magoo. Mr. Magoo, could you state your name again, please?
Daniel Magoo.
All right.
Yeah, I think we had finished with our officer, Officer Corey. I don't have any additional witnesses.
All right. Go ahead. You can have your conversation. You might want to mute the mic.
Your Honor, no witnesses from the defense.
All right. I have a motion.
Your Honor, I move to bind over as to count one and let counts, I think it's 2 and 3 on this one follow. I do believe we presented sufficient evidence to establish by probable cause a circumstantial case that the defendant was the operator of a motor vehicle on the date and time in question at the location in question, that he did have an alcohol content of 0.08 grams or more. Your Honor, the people were able to present evidence that there was a vehicle crash, that the windshield of that vehicle had been hit from the inside. There was blood and there was hair consistent with the defendant's hair. And the defendant had a head wound on the front of his head. And that, along with being at the scene of the crash, I do believe is sufficient circumstantial evidence to establish by probable cause that this matter should proceed to trial. I'll reserve any further arguments for rebuttal.
Your Honor, the defense would object to bind over in this matter. In making the bind over decision, we'd ask the court to consider the lack of direct evidence linking Mr. Magoo to operating that vehicle. Your Honor, I have nothing further at this time. For the record, we are objecting to bind over.
I think there is certainly, when one looks at the exhibits, particularly exhibits 1, 2, 3, are the vehicle in which the defendant is around, which has crashed into a pole, and that the pole, quite frankly, did not give way much. And then what also would establish, then there's a second piece of establishing the defendant was operating their vehicle, or People's Exhibits 4, specifically 4, which is clear indication of the spider webbing, and what Officer Corey testified to are the damage to the windshield, the circular damage above the driver's side, to the window, as indicated, a circular pattern, not or similar to certainly what this court has seen over the years of individuals who are unrestrained in vehicles who are then involved in a crash, alcohol related or not, where their head strikes the windshield. And then exhibit 7, 8, 9, and then also 10 that show blood and also injuries to the cranial area or the head area of the defendant, along also with Officer Corey's testimony regarding the hair, although not analyzed, but certainly the color, texture, hair, his observations regarding the hair that is in the windshield, all certainly point to and would give rise to probable cause that the defendant was operating that motor vehicle at the time of that crash. Additionally, then there is testimony regarding blood test results, which then occurred at the hospital later that day, indicating a blood alcohol content of 0.127, which, absent anything else, could be used to presume that that was his blood alcohol content at the time of the operation of the motor vehicle. So that the record is clear, even to the extent the defendant's unlawful escape from custody at the time from the hospital may go to the weight to be given to that blood alcohol result, but does not negate that blood alcohol result. The court is sufficiently satisfied that people have sustained their burden of showing by probable cause that the defendant did operate a motor vehicle under the influence of alcohol or intoxicants. So therefore, for those reasons, the court would bind the defendant over on count 1 with the stipulations to the previous convictions of the defendant, with counts 2 and 3 following.
Judge Simpson walks through the evidence piece by piece. Hair, blood, injuries, crash damage, all pointing one direction. Probable cause is clear, and the case is moving forward. This is where jokes end and prison math begins.
Your Honor, do you want to proceed on the arraignment?
Yes, let's just do that now.
We would waive formal reading of the information, stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all 3 counts. Pretrial in this case will be
October 9th at 1:30 with Judge Slay.
October 9th, 2025, 1:30 before Judge Slay. That case bond will continue.
Can I find information, Your Honor?
Yes, you may. Court also now calls the case of People versus Daniel Magoo. That's case 25F30979.
As well as the people?
Alex Warren Green on behalf of Mr. Magoo. Mr. Magoo, could you please state your name for the court?
Daniel McGrew.
All right. Ready to proceed on this case?
We are, Your Honor. Prior to beginning, I will inform the court, I did inform defense counsel, I do intend to, if the proofs, bear it out, to add of resisting or obstructing an officer. And I believe defense counsel is aware of that. That would be contrary to 75081D as in dog 1.
Okay.
Right.
And Your Honor, to also provide notice of this, notice of removal pursuant to 28 U.S.C. 1455. This case has also been removed to the United States District Court of Eastern District of Michigan under case number 25-12441 for Fourth Amendment violations along with others.
This court has no knowledge, as I last case, of any removal, has not been notified of removal, and so has not been presented anything with removal, nor anything presented which would show a procedure in which this state action would be removed to federal court. So for those reasons, while you want to say it all the time on the record,
Yeah, that's it.
to the extent it's a motion of any type, that's denied. You may call your first witness.
Thank you, Your Honor. People call Colin Cheney.
Sir, please come forward and be sworn.
Were you still employed on or about July the 3rd, 2025? What were you working that day?
That was road patrol.
And where were you road patrol at? Do you recall what part of Washtenaw County you were doing road patrol at about 7:45 in the morning? Were you traveling westbound on I-94?
Yes.
And is that location in Washtenaw County, state of Michigan?
Correct.
Did you notice any vehicles while you were traveling westbound on I-94?
Yes.
What did you see?
Coming up near westbound on 994, I observed a red sedan that looked like it was traveling faster than the rest of the traffic on the freeway.
What did you do?
I caught up to it, and when I got closer to it, my radar picked up the speed reading.
And what was it reading?
So 90 miles per hour.
What did you do next?
I got behind the vehicle, and activated my overhead lights to conduct a traffic stop on the vehicle.
What happened after you activated your overhead lights?
Shortly after, the vehicle merged over to the shoulder, got down to around 40 miles an hour and rolled for half mile to a mile before coming to a complete stop at about 40 miles per hour.
What happened after the vehicle came to a complete stop?
I approached the vehicle, spoke to the sole occupant of the driver of the vehicle, and told him I was Trooper Ching with Michigan State Police, and requested his driver's license.
Did you see what position that person was inside of the vehicle? Was he operating the vehicle?
Correct.
Do you see the person that was operating that vehicle in the courtroom today?
I do.
Can you tell me where he's sitting and what he's wearing, please?
He's sitting to your right in a green jumpsuit.
Your Honor, may the record reflect the witness identify this defendant?
No objection, Your Honor.
Record shall so reflect.
When you made contact with the defendant and asked him for his driver's license, what happened next? Did he say anything to you?
He did.
What did he say to you?
I can't exactly recall what it was that he said, but somewhere early on, he advised me that I did not have the right to stop him. And actually, right after I asked for his driver's license, he asked what my reason for the stop was.
What did you say?
I told him that I observed him on my radar. I observed his speed on my radar that was over the speed limit.
What happened after you told him that?
I requested his driver's license again.
Did he give it to you?
He did not.
What happened after he didn't give you the driver's license?
stated that I did not have a right to stop him because he was traveling in a private capacity and not a commercial capacity.
What did you do?
I advised him that he is required to provide a driver's license at the request of a peace officer.
Did he provide you a driver's license?
He did not.
Did you observe anything about the vehicle's license plate?
The vehicle's license plate did not look familiar to me. I had not had a chance to actually run the plate.
Okay. So while you're at the side of the car and you're speaking with him, are you continuing to request his driver's license?
Multiple times.
Is he ever providing it to you?
No.
How long do you think, well, I want to ask that question. As this is going on, what are you doing?
While I'm speaking with him, I requested for back because he's not being very compliant.
You asked for what?
Backup.
Backup? Okay. At some point, did you return back to your vehicle?
I did.
And what did you do when you got back there?
I attempted to run the plate. Did not seem that the plate existed, essentially.
What did you notice about the plate once you were able to examine it?
It was not registered to any specific state.
Do you recall what it said on it?
It's a diplomat on the top, non-expiring on the bottom, and I believe it said non-commercial.
Next case, new stunt, a fake diplomat license plate. Refuses to identify himself and claims he's above traffic law. Michigan State Police are not impressed. Sovereign fantasies don't survive traffic stops.